In this video, we'll answer another question from one of our subscribers, and this is regarding somebody who was removed from the United States many years ago, and now they're married to a US citizen, they want to come back. Is that possible? Watch this video and learn more. In this video, we'll answer a question from one of our subscribers about deportation and coming back to the United States and being married to a United States citizen. But before that, if you're here for the first time, click the bell, subscribe to our channel. If you are on Instagram, follow us on Instagram, and leave us a comment, share this video. We really appreciate it. We're making these videos for you guys. So it's a question from one of our subscribers, somebody who has been in the United States. He was deported less than 10 years ago, and since then he's been in his home country all these years, and now he's married to a US citizen and he wants to come back to the United States. So it's a really common question that we get, specifically on our videos that we did about waivers, 601 waivers, 601A waivers. And we've done quite a few videos about waivers for people that are currently in the United States, came here illegally or committed a violation. In this particular video, this is about somebody who is outside of the United States after being in the US illegally many years and then being removed, and now they're married to United States citizens. So the issue here is that once somebody is removed, they typically have bars. It could be 10-year bar, it could be 20-year bar, depending on the case. And there are waivers that will that can apply. It depends really on the situation. Some people who have been deported and they spend the amount of time that was on their order, if it's 10 years or 15 years or 20 years, and after that time they can try to reapply if they have a way, or sometimes they need a waiver. So the right way to do it is first to understand whether the person has any waivers or any recourse to come back to the United States. Some people have a life bar, which means that there's really no waivers that are available for them. That's why it's really important to look at the record, to look at the deportation record, to look at if there's any criminal records, if there was any multiple entries or deportations. There's so many factors that can come into this. That's why I think this video is so important to understand. So for people there's so many people that are losing hope. And again, before we analyze any case, we really have to ask all these questions. When were you deported? Was it less than 10 years ago? Was it more than 10 years ago? Did this incident happen before 97 or after 97? Because there's been so many law changes, especially since 96, 97, around that time with the new legislation, and so many people that were here before that or after that, things are really different. And so it's really important to speak with an immigration attorney that can analyze, when did you come to the United States? When were you deported? How many times were you deported? And based on that, determine if there's any waivers available for you based on marriage to a US citizen. Remember, if you're not married to a US citizen, there's really nothing we can do. But the fact that you're married to a US citizen, now there may be some options, whether there's certain waivers that are eligible, that you're eligible for, or things like that. So to answer this question, again, it is really important to understand and make that analysis. When did you come to the United States? How long have you been living here? Are there any other violations except from the illegal entry and illegal overstay? And that deportation, is this the only deportation? And based on that, we can determine if there are any other waivers. Can we do an I-212 waiver plus a 601, which is the waiver based on the overstay? Are you even eligible for that? How many waivers we need to do? So that's kind of the analysis that we do when we decide how we can bring somebody like that who is now married to a United States citizen but living overseas and trying to come back to the United States. We've done quite a few of these waivers, even for people that had criminal violations. Again, as long as you qualify for the waiver, and the law is pretty specific as to who qualifies and who is not, then we can kind of create the plan and fit that person into the program and start working on the waivers while we do the petition to bring them over here. Remember that you can file the waiver at the same time as you file the immigrant petition, the I-130 and all the other forms, because that waiver has to be processed before you can actually get the petition approved, or you can do the waiver just before or after the interview, it depends. The idea is that if you're eligible for a waiver, that will be the best way to bring you back to the United States. If you don't need a waiver, that's also something that can be analyzed depending on when it happened, or when you need to come back. And if you're not eligible for anything, then that's something that you also should be aware of, because some people are just not eligible for anything and they just have to wait for the law to change. So hopefully you found this video beneficial. Again, it's a kind of a complicated matter, very sensitive, and quite a few people are in that situation. But I think the purpose of this video is just to let people know that there are options, but it's important to make an analysis as to when the person was deported, how long have they been in the US illegally, when they married a US citizen, and how to bring them back to the United States with a clear and concise plan. So thanks for watching. Make sure to subscribe and share and leave us a comment if we can answer any of your questions. Thanks for watching. I will see you in our next video.